Court is calling 2024 CR 008620. State versus Joshua Pardo. Can I have parties announced for the record?
Lastly, Sahonovich for Mr. Pardo. Mr. Edelman's for the state.
All right, for the state. And are you Mr. Pardo? All right, you entered a plea on October 17th. According to the plea bargaining agreement, punishment is to be assessed at a cap of 6 years, and the state is silent on your recommendation for probation. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Your Honor.
Any objections to the PSI report, state? Defense?
And,
Have both parties reviewed the TAP evaluation?
yes, we have.
Any objections to the TAP evaluation, state? Defense?
No, Your Honor.
Any witnesses,
No.
defense?
No, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. He has been able to gain gainful employment. It starts Friday, and it's the back caver. Over on Goldfield Road. He has never been on probation before for a felony.
I'm sorry, what?
He's never been on probation before. According to the.
No, I mean, I'll let him finish because I'm looking at I see
Oh,
the,
okay, I was basing, if I'm mistaken, then, I apologize. I'm basing, based on what I find. So I'll withdraw that part.
all right, so what I can tell you is he has been on probation for evading arrest, detention with a vehicle for 6 months, deferred adjudication. A motion to revoke was filed, it was withdrawn, and the case was dismissed. He was on probation for DWI in 2002. Probation was revoked and he was sentenced to 4 months in jail. He was sentenced to 6 months in jail for assault bodily injury in 2003. And also in 2003, 6 months in jail for interference with emergency telephone call. 2004, he was placed on DWI second probation for 2 years. His probation was revoked and he was sentenced to 6 months and 20 days in jail. 2004, he had a criminal mischief, $500 to $1,500. He was given 2 years probation. A motion to revoke was filed. The motion was granted. He was sentenced to 6 months and 20 years. 2024, he was charged with escape. He was given 2 years probation. A motion to revoke was filed. Motion was revoked. He was sentenced to 6 months and 20 days in jail. 2006, he was sentenced for assault bodily injury married to 4 months and 20 days in jail. 2008, assault bodily injury. The offense was reduced and he was sentenced to 60 days in jail. 2009, violation bond or protective order. He was placed on probation and MTR was filed. Probation was revoked. He was sentenced to 7 months and 20 days. 2010, violation bond protective order, 56 days jail. 2014, assault bodily injury. That was a felony. It was reduced to misdemeanor. He was sentenced to 1 year in jail. 2017, assault bodily injury family household, 5 months jail. 2019, criminal mischief, $750 to $2,500. He was placed on probation for 1 year. A motion to revoke was filed. Probation was revoked. He was sentenced to 90 days in jail. 2023, criminal mischief, $750 to $2,500. He was sentenced to 10 days in jail. 2024, terroristic threat causing fear, 80 days in jail. 2005, evading arrest, detention with a vehicle, 12 months state jail. 2010, possession less than a gram. He was given 2 years probation. The probation was revoked. He was sentenced to 9 months in the state jail facility. 2012, assault family second. He was given 5 years deferred adjudication. Probation was revoked. He was sentenced to 3 years in prison. 2014, possession, 1 to 4 grams. He was sentenced to 3 years in prison. And now we are here. All right. Anything you wish to say about your client's behalf?
Other than what I said previously, no.
All right, and state you had something you wanted to say?
I did, Your Honor, but it's already.
All right. Anything you wish to say, Mr. Parau?
I am terribly sorry.
You want to raise your right hand for me? Do you
Yes.
solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I swear.
All right, you can lower your hand, state your name for the record.
Joshua Javier Pardo.
All right, you stated there's something you wish to say?
I'm terribly sorry for my behavior. I was on a reckless path. I didn't know. I also suffer from bipolar 1 disorder and PTSD. I wasn't on medication at the time. I have been trying to better my life for quite some time. My family is here in support of me. They have been very patient with me as well as I have tried to.
All
better
right,
my
I
life.
still don't understand why you went to the Dollar Tree and threatened the employees
I
and
went-
start breaking items.
Yes, ma'am. I went, I didn't have my glasses at the time. I tripped over something and I thought I heard her chuckle and, I lost my, subsided and took over. I knocked over, a stand, I believe probably $13 of damage. I was able to apologize to the cash, register woman and, she had told me that I wasn't allowed back at the store. I am on GPS monitor. I have been obeying everything.
Now, what it says in the stipulations, I'm not the one who accepted this plea, but what it says in the stipulation is that victim said suspect was verbally aggressive with them and that suspect verbally demanded money for an alleged recall of items from employees, victim 1 and victim 2 at the incident location. Suspect then started breaking items inside the store that were valued at approximately $13. Once he realized that he was not going to receive any money from the business. So there's nothing about you tripping over an item. It says that you went to the Dollar General, you wanted refund. They told you they were not giving you a refund. And then you proceeded to destroy items. And then you told them that you would shoot up the incident with the gun. So that's what you stipulated to.
I did say, Your Honor, that's why, that's why people ended up getting shot. But I did not threaten to shoot up the store. I have no way of getting a gun and, I'm not that type of individual to open fire or anything.
All right, the court is going to deny your application. The court is going to find you guilty. According to the plea bargaining agreement, punishment is to be assessed at a cap of 6 years in the prison. Defense? The agreement is cap of 6. Do you want to speak to the cap?
I think based on the facts of this case, we've asked the court to assess 2-year punishment. Judge.
All right, the court is going to find you guilty. The court is going to sentence you to 6 years in the prison, and the court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yeah.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. I'll recommend the therapeutic community for you. It doesn't increase the time that you're in custody, but it can help you perhaps with your mental health issues, any anger issues, or any drug issues that you have. You understand? I want you to know that I listened to everything that your attorney said. I reviewed the stipulations, even though I'm not the one who took the plea bargain agreement. And I reviewed the TAP evaluation, and I reviewed your PSI report. All right? So you're gonna have to start improving your life. You understand? All right, good luck to you. Dominique Camacho. Good morning. All right, I just received the felony packet, so I'm signing that. All right, court is calling 2024 CR 009127, State versus Dominique Camacho. Could I have parties announced for the record for the state? Defense,
Gable Sadowski, Judge.
and are you Mr. Camacho? Counsel, have you received all discovery and did you review it with your client?
I have, Judge.
Court will find that the state is in compliance with discovery. Did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Counsel, is this an application for deferred?
Yes, it is.
All right, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented? Did you review the court admonishments and defendant's waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with assault choking? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand by giving up by entering this plea, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your probation were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Camacho, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, there's a $1,500 fine. State recommends deferred adjudication. There's an affirmative finding of family violence. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Correct, Judge.
State, is that the plea?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be no harmful or injurious contact with Brianna Cabrera. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary or custodial parent? Knowing that, do you still wish to continue with this plea? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Okay, the state's exhibit one and all attachments.
No objection, Judge.
All right, and state, have you spoken with the complainant?
You have your-
All right, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, he's fully employed. He works in the oil field. He's sees his child. The mother of his child is the alleged victim in this case. And he sees the child who's paying.
Excuse me, if you all could talk on that end, the deputy will move towards that end. You may continue.
He's paying child support in that case, and he's trying to be involved, and he's fully employed.
All right. So here's the thing. If you think somebody has cheated on you, you have 2 options. Either you accept it and don't bring it up again, or either you move on and say, you know what, I can't accept this. And you still don't bring it up again. The relationship is just over. Do you understand?
Yes, ma'am.
And your 11-month-old, is this a boy or girl?
Just turned 2.
All right, so let me explain something to you. Children mimic what they see.
Yes.
That's how children learn how to speak. If you have a son will think that you love his mom, because that's what children think. And if they see you being abusive towards their mom, they will think that's how you show love. Then they go on in their relationship and they be abusive. You understand?
Yes.
So I'm going to order no contact with Brianna Cabrera. What you'll need to do is you all can do exchanges. Do your grandmother, I read in the police report that she discovered that he had taken the baby then 11 months to the grandmother. The only way I'll change that no contact order is if she comes in and tells me she wants the no contact order changed. But I don't do no harmful or injurious contact until I at least spoken to the complainant. So there's to be no contact with Brianna Cabrera. Regular reporting by Zoom or in person. Regular random UAs. There's an affirmative finding of family violence. Proof of employment within 30 days. No employment as a home health care provider or with minors. 100 hours of community service restitution. I'm going to order parenting classes. Once you complete the parenting classes, the community service hours will be deemed satisfied. With regards to was Child Protective Services ever involved?
Yes, she actually made me take a fatherhood class it was a 9-week domestic violence class that I took.
Mhm.
And it was her recommendation, so I took it and I did the 9 weeks.
When did you do that?
I did it, I can look at the email when I finished it, because it was like a couple months ago
All right.
before I moved to Odessa.
Judge, is there a chance that, I understand the court's position so far is no contact, but in light of the fact that he is an active participant in the rearing of his child, is it amenable to the court to have family wizard as a form of contact? Because family wizard allows all that communication to be done in writing electronically. And so if there is an issue with that, then they don't have to wholly rely on an intermediary, which is the grandmother.
All right. My order stands.
Okay.
Once the complainant, if the complainant comes in, and they can come in by Zoom if they want to come in by Zoom, if they have no issues, and if he's completed the courses as he said he's completed them, then the court will reconsider.
I can provide email and stuff as well.
All right. I'm going to order the BIPP course probation. If he has completed everything through CPS, and that was the parenting classes and the family violence course, then that will be acceptable to the court for the BIPP and the parenting classes. What is your off time from working?
I work 6 days a week, Your Honor, Monday through Saturday at 7 to 5.
All right.
Sometimes even more.
All right. There's going to be field visit one time. Probation. Is there anything else?
You just want it one time period then?
Yes.
Nothing else.
Another county, but that's.
So Judge, he works in Permian Basin. He's in the oil field.
All right.
So
So where
he's-
does he live though? Does he live in Bear County?
I live in Odessa.
All right. Probation. He lives in Odessa.
Are you giving him permission to transfer, Judge?
Yes.
but I frequently travel, like, obviously, I put this a lot because I'm a parts runner, so I constantly.
All right, let them know. And what county is Odessa?
I don't,
I'm sorry, what?
I'd eventually get that out of the 254 judge, but I didn't.
Okay. All right, so he's allowed to transfer to Odessa County. I'm sorry, Odessa, Texas, which is Ector County. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. In this court, to be successful in probation, communication is key. If you have an issue, let probation know. If there's an issue and they say that you can't travel, don't just stop reporting. Let probation know. If you feel as though they're not addressing it, you can always come to the court and address it with me. All right, thank you for addressing appropriately for court. Once you
The courtroom falls quiet as Judge Stephanie Boyd calls the case of State versus Joshua Parau. From the start, the tension is unmistakable. The plea agreement caps punishment at 6 years, with the state remaining silent, leaving the decision entirely in Judge Boyd's hands. She carefully confirms that both sides have reviewed the PSI report, already signaling that this sentencing will not be rushed. Defense counsel attempts to paint a hopeful picture, highlighting employment efforts and noting that this is the defendant's first felony probation request. But Judge Boyd immediately cuts through the narrative, pointing out prior probation for evading arrest. Her tone shifts from procedural to piercing. She has read the report. She knows the history. When the defendant speaks, emotion fills the room. He apologizes, describing his past as reckless and uncontrolled. He cites bipolar disorder and PTSD, insisting he is trying to rebuild his life. But Judge Stephanie Boyd zeroes in on the incident itself. She asks the question that matters most. Why did he enter a Dollar Tree and terrify employees? The defendant scrambles to explain. No glasses, a stumble, minor property damage. He firmly denies threatening to shoot the store. But Judge Boyd is unconvinced. Her frustration is clear. The explanation does not match the severity of the report, and the fear inflicted cannot be undone. The defense pleads for mercy, 2 years instead of 6. It's the last attempt to soften the outcome. Judge Boyd pauses, then delivers her ruling with absolute clarity. Probation is denied. Guilty is affirmed. The full 6-year prison sentence is imposed, with credit for time served. In that moment, Judge Stephanie Boyd destroys any hope of leniency. The message is unmistakable. Excuses do not outweigh public safety. Accountability is not optional. And when boundaries are crossed, consequences follow.